we'll start, they can catch up. Okay, so as I said yesterday, because I work for Conflict Public Defender, I'd say 80, no, probably close to 90% of my cases I have a co-defendant. The other ones are ones where the public defender has a conflict because they represented a witness, or are currently representing a witness on some other case, or the client has decided that he's running the show and has fired the public defender, and some judges let him do it, and poof, now I have this guy in mind. But let's talk about co-defendant cases. So, you got co-defendants, right? What's your greatest fear when you have a co-defendant case?
The other one's gonna flip on yours.
Flipping, okay. What else? Any other fears?
Say something that'll knock the leg out from under what you're trying to say.
Okay, yeah, the non-cooperation or there's problems in just the fact when I get the pleading and there's two names on it, this is my greatest fear, is this guy, right? Because I like to have some feeling of control. I like to know what the fuck's going on here, and I like to be able to control things. And this is what worries me, is this guy who is going to be ineffective, and who knows? You know, the client might end up flipping because he doesn't know what he's doing. So I get a pleading. I've got two names. I'm scared shitless. Then I go into court and I meet co-counsel, and all of a sudden, you know, it's not that bad. It's somebody that I can work with. So we can talk about what we can do. In a co-defendant case, you start off together. And when you're together, things can be wonderful. You can do stuff that you never dreamed of. Now, understand the prosecutor wants you together, so you don't want to be together. You really do. But you don't want them to know that you want to be together. You want to make the severance motions. I'll come to that in a bit. But I just want to talk about some examples. With two people, with two counsel, you can make the prosecutor's life a lot more difficult in a lot of different ways. And that's the beauty of a co-defendant case. These slides were exported from something else, so I don't know what's going on. Okay. Just the fact that there's two of you there means that you have more stuff to work with. Providing your co-counsel's not dipshit. And if it's dipshit, well, that's a problem. But just having two of you there, there's ideas that come up that you didn't think of. Just with the brainstorming power of talking about the case, trying to figure out, okay, what about this? And okay, we'll talk about that. So you've got a defense. You think you've got a defense, and we're going to go with we'll go with they weren't there. At least that's what my client is telling me. Your co-defendant has read the discovery, your co-defense counsel has read the discovery probably differently than you have, because they're looking for stuff for their client. And you know, as we're going through for our client, we're seeing stuff and going, okay, I can work with that, this one's got a problem, I'll have to deal with that. But we're focusing more on our client. The co-defendant's attorney is focusing more on her client. So she's reading it differently. So when I go, look, I think we've got a defense here, I think we got this shot, clients weren't there, they're a little thin on weren't there. It's the co-counsel that'll say to me, well, Bart, what about this fingerprint? What about this? They got my client there. If you're going to go with they weren't there, this fingerprint's going to take me out, going to shoot you out of the water, Bart. Oh, okay. Well, maybe I'm not going with they weren't there. But just having the ability to talk to co-counsel. When you're by yourself, you know, we brainstorm cases in the office, you know, we'll talk to other people in the office, but we only see it from our little blinker thing. You know, we got the blinkers on. And the brainstorming in the office, when you storm a case and people are asking you questions, it gets the blinkers off, but there's nothing like the slap in the face of co-counsel going, you stinking idiot. You don't know what the hell's going on. Look, we're dead in the water. if you're a sole practitioner, as I was for a long time, before I ended up in the public defender office, other than going out to lunch with my buddies and bouncing cases off them, I didn't have anything else. In a co-defendant case, sometimes your co-counsel knows more than you do about DNA. I could learn DNA. I've learned it a couple of times, that technology keeps changing, I have to learn it again. But sometimes you get co-counsel who knows DNA. And when you're in a DNA case with someone who knows DNA, you say, okay, we're going to have a DNA hearing. Great. You do the questioning. And they'll like that. You know, that's their thing. It wasn't my thing in a particular case. So I turned it over to Chris, not Adams, a different Chris back where I come from, who's our DNA expert. He knows more about it than the scientists that they're putting on the stand. And so, as we go through the hearings, he can bring that. Now, the other benefit there is, let's say DNA is not, it could be an issue, might not be an issue. If Chris is on the case, and we file a motion about the DNA, what's the DA do? Run screaming into the night. Because they know, oh my God, this guy has done all these DNA cases, he knows what's going on. So you can take advantage of co-counsel if they have specialized expertise, particularly in scientific areas. Scientific areas, you know, tool marks, fight marks, all the bullshit sciences. Some of them have are really good at handling those things. So that's a benefit to having a co-defendant. You still have dipshit for co-counsel, you're not going to get there, but get somebody in the case. Let's see what else is up. Okay. What do you got when you got two lawyers? Two cross-examinations. The first capital case I had, there were two, Hector and Ronnie, great clients. And in California, you would get two lawyers. You did then. And it was a 3.5 body murder. And that was kind of the problem because Pete survived and was the star witness. He had 3 guys with 38s in their heads, Pete with a 22 in the butt. That just isn't going to make it. You know? Pete ran. So, and we were in front of a judge who had never done a capital case. It was the first for all 4 of the defense lawyers. So we're all sitting there. And Pete gets on the stand at the preliminary hearing. And we said, well, Judge, we need to cross-examine Pete. The judge goes, oh, sure. So, well, we all need to cross-examine Pete. We're 4 lawyers. We all need to do it. And she didn't know to stop us. So Pete was on for 3.5 days at a preliminary hearing. An hour on direct, the rest of it on cross. And we went through every possibility, you know, and locked him in, and we get different versions, and each one of us would get different versions, and each one of us had a different style. And we ended up, and of course at the end of Pete, who was the first witness, the judge said, you know, I think from now on it's only 1 lawyer per defendant that's crossing. Well, who cared at that point? You know, but the more times they testify, the more you can get. And that's what you need. So, co-counsel helps you there. In that particular case, back to Yala, not OJ, but Hector and Ronnie, we had a couple of lawyers on the various teams, 1 lawyer on each team, who was a really good writer, researcher. And so we could, when we had a legal issue that came up, because we were all working together, we could say, tonight Bobby's doing that. And Bobby would go off and research that, and write that. And we'd all, and you know, that was before the internet, I think. And before email. So Bobby would print up a pleading, bring it to court the next morning, we'd all sign it, poof, there we were. So having a separate defense team that had strengths, we got the benefit of Bobby. Hector got the benefit of Bobby. There were other things that we did on our team that they got the benefit of. But just having that second defense team Let's say that you're in a jurisdiction where you're trying to get money for experts. If you're working together, one client can get the expert money. And we can both use it. Now, I personally believe that if you're working together, you should utilize a joint defense agreement. Are they enforceable? No. Do they look enforceable? Yes. There's some Ninth Circuit case law that kind of gets you to enforceable, and there's some cases in other jurisdictions where you can enforce a joint defense agreement. And you need a joint defense agreement in case we have some flipping later. And if you're in a multiple defendant case, you're worried about somebody's lawyer attending your joint defense meeting, and they're with you, and then flipping later. And how much can they disclose? So you just, I can send you one if you email me. I'll send you a joint defense agreement. They're kind of blood oaths, but as I said, they're unenforceable. But if everybody thinks they're enforceable, we're okay. And if we're hiring an expert, and we're all going to use that expert, then I definitely need a joint defense agreement. If our expert's going to test some DNA, and let's just say the results don't come back the way we would have preferred them to be, I don't want my co-counsel to be able at any point to disclose that to the government. Because I can bury it, but if the co-counsel, if the co-defendant pleads out and flips, I don't want his lawyer to be able to say, well, they tested the DNA, we tested the DNA. Now the government knows when we test, but they don't know the results. So having a second defense team takes care of that. Investigators. If you have in-house investigators, great. If you're having to hire investigators, having two teams, you have different investigators, and they can do the work. Sometimes an investigator is really, really, really sensitive. You know, I'm sure you have those investigators that can go out and interview witnesses, and they're just so empathetic, and the witnesses just talk to them. And then other times you have Paul Drake here, who's kind of ex-copy, who's good at doing certain things, but I never think of him as being Mr. Touchy-Feely. So having more investigators on the case, you have different styles. You can say, look, we need to go out and interview this person. How are we going to get this person to talk to us? Who's the best investigator to do this? If you're just single defendant, you're stuck, sort of. If you're in an office, a public defender office, I can go to the chief investigator and say, listen, can I use such and such for this task? And maybe I get it, maybe I don't. If you're getting money from the court for your investigator, when you want to get a second investigator working on your case, it's like pulling teeth. You think, you have an investigator partner. What do you need another investigator for? Well, I need one investigator that's really cop-like, that can do all the cop shit. And I need somebody else that can kind of open people up. Go into their homes and open them up. And judges go, no. That's the answer. Couple defendants, we split it up. Next slide up. Okay, the attorney divide up legal, we've done that one. Okay, 2 openings and 2 closings. It's a lot for the prosecutor to deal with. If we're together, now I'm talking now, we're joint defense, we're working together. We can make the same points, our theory of defense, with different styles in different ways, all the way through the case. And then two sets of voir dire. Oh, this is a great one. So you got a case. There's a slide comes up later, but I'll talk about it now. So Gary and Larry made the mistake of going to a heroin dealer's house to buy some heroin. The mistake was they didn't really know Nacho. Angelina knew Nacho. And Angelina knew Gary and Larry, who were heroin addicts and needed heroin. So Angelina says, Nacho's got some dope, go to Nacho's. So Gary and Larry show up at Nacho's to buy heroin. They have some money. Larry's got a gun in his pocket. in his back pocket because people could take their money. I mean, it's not like they're buying a bunch of heroin. It's just a little bit. But, you know, out on the streets, sometimes you carry protection. So Larry's got a gun in his back pocket, and they walk up to the door and they knock on the door. And Nacho's not expecting anybody. So he looks out and he sees two strangers. What does he think? What?
Cops.
Cops?
Rip off.
Rip off? Right. He's not excited about answering the door for two strangers. Fortunately, these guys look so scuzzy. They don't look, Gary and Larry don't look like cops. So but he's certainly thinking rip off. So he picks up a frying pan to answer the door. He goes to the door with a frying pan, opens the door, sees these guys, and starts to swing. Actually, Gary had the gun. Gary pulls the gun out and shoots him. And he dies. And unfortunately, the trail leads to the boys. We needed someone to tell the story of the frying pan and the door. We needed someone to make Nacho the aggressor and these guys defending themselves. Problem? Gary and Larry they had criminal records. Gary was on parole for robbery. Oh, that's a bad one to be on parole for. Larry had some stolen property stuff. And so, having two people, we could pick the defendant. Larry testified. Larry was more articulate than Gary. Gary looked a little scarier. We didn't want Gary on the stand. Not only for impeachment purposes, but because he just wasn't going to do as well. And so, Larry got on the stand, testified, told the story. We got the frying pan, we got all this stuff, oh my God, we were just there to try to buy dope, he's a dope dealer, everything's fine. And it worked well enough that Gary got acquitted. His lawyer did a great job. I was Larry's lawyer, we didn't get acquitted. We got acquitted of murder. The jury hung 6-6 on voluntary manslaughter. And the DA decided they wanted to retry the case. I still didn't want to call Gary for the retrial. Larry had done okay. I was persuasive enough with some of the jurors, and particularly one who then posted her house as bail for Larry because she felt he was innocent and was really pissed off that the other 6 jurors wouldn't find him innocent. So Larry gets out, working, all this stuff. And we didn't have to try it a second time. He pled to involuntary manslaughter, time served. But it would never have worked if they both had to testify. If I'd been severed, and of course we tried for severance because I knew they didn't want it. If we tried for severance and Larry had been tried by himself, it would not have been as good because my co-counsel did such a spectacular job with the jury that she walked her client and nearly walked mine. And that, I mean, we were lucky because that's how they could do it. Okay, all right, so let's talk about your co-defendants on the hit is out there. Well, the DA is going to get to cross, right? The co-defendant. What happens before the DA crosses the co-defendant? Tried these. What happens? Direct. Larry's on direct. Nice story. Good job. Cross-examination. Who crosses him first? Where I come from, Gary's lawyer. Because they want. I mean, the judges think they're helping the prosecutor by giving the prosecutor one shot to respond to all of the stuff coming out. Well, what does Gary's lawyer get to do?
Fix it. Any problems.
Fix any problems. And how? How do they get to fix the problems? Choose the most articulate witness. We already got that one. Okay, I don't. All right. Co-counsel gets to lead. It's cross-examination. Now, instead of me relying on Larry being a great fucking witness, I've got co-counsel asking the leading questions. When you went to that door, you didn't know Nacho. Sometimes when you go to doors and buy dope, you get ripped off. And so sometimes you carry a gun. I hope you never have to use a gun, but you get ripped. I mean, absolutely leading questions all the way through. So we got direct, Larry doing a good job. We got cross of Gary's lawyer. Larry saying yes 1,000 times to perfect questions. And then, okay, you're a witness. Well, how the, you know, by the cross-examination, by using the leading cross-examination, we were helping Larry remember the story. So then on cross-examination, Larry was double prepped to deal with the prosecutor. And it worked really well. Okay, leading questions, right? You can choose the words you want. You get your inflection. It's why we like cross. And in a co-defendant case, if the co-defendant testifies, you get to cross. And so working together, you get your theory of defense, your story is perfect, and you get to tell it twice. Once on direct, once on cross. And then the DA has to jump in there and try to fix things. Let's see what's that next step. Okay, problem areas for the defense. Okay, yeah, defendant with a record. That's Gary. The damaging post-arrest statement. One guy's done badly, and the DA has a Rand or Bruton problems, so they can't put all the co-defendant's statement in because of Bruton. Rand is California case because of Bruton. So they're kind of constricted a little bit if they want to try us together. The other guy, maybe the other guy's statement, post-arrest statement, they don't have the Bruton problems, but it's not as bad for us. By picking one defendant to testify, we limit their impeachment. We limit what they can go back into. Because, you know, if there's a Bruton problem, once the speaker takes the stand and is subject to cross-examination, there is no Bruton problem, right? It's gone. So you got to be careful about what that statement is and how far they can go. Maybe you're not going to get a severance because the judge doesn't want to sever it, and they'll tell the prosecutor, just clean it up. But once one of them gets on the stand, you've opened a door. You've opened a door to that whole statement. So you got to pick you can choose the one that has the least damaging statement. If that's what you can do. I just always like to have Carl Rove in the slide. Although he had more hair then, didn't he? He was only this big guy. When you have the option with co-defendants, there's a lot of stuff you can do there. Let's see what else we got. The DC shooters. This one, you can minimize your client's role by using the co-defendant in the same trial. Because you're downplaying your client. This you can do anyway if it's a separate trial. But in a co-defendant case, you know, sometimes they have more evidence against one of them. And I personally try to do no harm in a co-defendant case. I don't like to lay out my co-defendant. But sometimes, just the way the evidence comes out, the co-defendant's done a bunch of stuff. His name gets mentioned a lot. I'm just down at the end of the table. I have no questions. I have no questions. I have no questions. Sending the jury a message. They have no evidence. They have no evidence. So, just the minimization of your client. Yeah, sometimes you have the unknowing dupe and the compare and contrast to the jury. Let's say you get a severance, all right? You get a severance, the co-defendant is ugly, disgusting looking, you know, is the perfect defendant. So you got a severance. So what do you do now? I guess I'll talk about this part there. We'll talk about this right now. What do you do? Come on, I don't have any answers. I mean, I have answers. What do you do when you have a co-defendant that your case is severed and you're in trial by yourself?
Point at them.
Yeah, you're pointing at him. Bring him into court so the witnesses can identify him. Right? If I'm dumping, we're dumping all the way. And when he comes into court, is my jury going to be prejudiced by the fact that he's in shackles? No. They can't have my client in shackles, that would be prejudicial. So, you got, particularly in a serious case, you bring the co-defendant in, how's he come in? We don't have him on the witness stand. On cross-examination, can you bring him in now? Man, would you look around the courtroom and see if you can see the man that came to your bank counter with the gun? Oh, that's the guy? The one in the chains? Thanks very much, you can take him out. I mean, I hate to do it, because it really, 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 really pisses off the co-defendant. But, you know, if they're severed, then I can't stop it. Yeah.
How do you, this may be a dumb question, but how do you just subpoena him but not call him as a witness? I mean, how do you make them?
I subpoena him and not call him as a witness. I want him in custody, I want him produced, I'll get a judge to order him produced. I said, Judge, they're gonna need to identify him. And they'll go, well, we can just do a photo. You can do a photo, Bart. I go, you know, those photo spreads are so bad, and a single suggestive photo is just not good, Judge. I think the witness needs to see them. Now they'll put a stop to it if I do it too much. But for one witness, I can truck the guy in. I only need him to see this guy once.
Yeah.
They'll never forget him. But remember that you can use the co-defendant as an exhibit. You got a co-defendant case. This can be together or separate. But your client is in a, particularly if we're telling the story, my client, one defendant can say, you know, I didn't know the players, he knew the players. I just kind of came into the situation. He knew the players. And they can both have a reduced culpability state of mind, but when one client is a latecomer to the whole mess, or doesn't know all the players, there's a latecomer, didn't know the other people involved. I mean, take this case, right? Take Fargo. Is he going to be at the defendant's table in trial? Yes, he is. And what's he going to be doing? Gosh, I didn't really know them. They just came in. Things just spiraled out of control. And is he going to be pointing his finger at anybody else? Yes, he is. Okay. Beware the breakup. When trial strategy separates and you're in trial together. That's why the joint defense agreement helps some. It doesn't solve, it may solve the problems of the DNA testing, but it's not going to solve things at trial. So, in a co-defendant case, when you're not working together, it's tough, right? It's real tough. All right, let's see what we got. But now let's talk about the benefits of being apart. If we can get the case severed, there's just more ways the case can fall apart. Terry Nichols is alive today because the government had to try it twice. And also because, again, Michael Tyke. But their case fell apart the second time. Fell apart in part because of the lawyer, and in part because they just had to do it. They had to do it separately. These are those statements. This is what I got here. Oh, all right. You want multiple trials if you can get them. I'll talk about that. I guess I'll talk about that. You'd like, if you have a co-defendant case to start with, you want it separated because of these benefits, if you can get them. Multiple chances for impeachment. The government just running out of steam. Have you ever experienced that? They try one, they get a conviction, and they don't care so much now. They really don't. Even if they perceive your client as the heavy, they've got somebody. And the cross-examinations, their directs, they're tired. They're beat down. I don't like to try a co-defendant. If we're co-defendants who were separate, I don't like to try one right after the other. Because I want the transcripts of the first trial. I need that for the second trial. But I counsel you, don't delay it too much. Get that prosecutor when they're tired. Or figure out when their vacation is and schedule it kind of around then, so that they've got other things on their plate. Most of the time, when a case gets severed and they've tried one client, you can get a deal that you couldn't get before, most of the time. Because of trial fatigue, because they've got, they've got the pelt they can nail on the wall. And so it helps if you can get severed. Let's talk about the severance here. Okay. Severance motions. In general, we've got Bruton, right? That's the easy one. And then, they'll kind of try to prune around the statement to try to use it. The trial that I was supposed to start next week, and now it's not till October for some other reasons. The DA files a pleading. He wants to try us together. The co-defendant makes some statements after arrest. He wants those in. Unfortunately, they're questioning him about my client. So he's got some problems. But they're not bombshell statements, okay? They're just little tiny bits that he knows my client, which is fine. We admit they know, but the prosecutor thinks he has to prove it, so we're going to make a big deal out of it. At any rate, so he wants to try us together. So he files a motion for dual juries. Do you guys do that? The prosecutor, dual juries? We have, California, shit, it's craziness. We actually have a couple of courthouses that have courtrooms that have 2 jury boxes in them. So that you can impanel a trial with 2 juries, 1 for each client. And then when there's evidence that's admissible against one, the other jury's excused for that afternoon. And the DA says, I want to do this because that way I only have to bring in all my witnesses once. We don't want it. Well, actually, my first choice, completely separate trial. Second choice, a separate jury, because that'll help me some. The dual jury procedure, I hate. So he floats this idea to our judge last week, and she goes, we're not doing dual juries. She says, we're just not doing that. She says, every judge I've talked to that have done that said it's horrible. The logistical nightmare of keeping them separate. One jury says something to a juror and another jury about something they didn't hear. Even when they don't hear it. My jury goes home and the other jury stays. What's my jury thinking? Oh, there's some shit on the other guy, which I like. But when my jury's there and the other jury's not there, they're all speculating. So both guys are getting painted with the bad evidence just because the jury knows by the fact that someone's excused that there's bad evidence. So I hate them. Unfortunately, the judge hates them. So he wants dual juries. Why? So he can put in these little tiny statements. The judge, because that ain't happening. I said, well, why don't you just sever us? Just sever us. You can try this case twice. Not a problem. No, I'm not doing that. I'm not going to do that. I'm not severing them. I'm just not going to use the statements. Poof. By just forcing the issue, I kept out the co-defendant statements, some of which were a little damning to him. The rule most places is you got to make your severance motion. It's denied. You got to renew your severance motion. You got to renew it every single time. Well, you got to renew it at least during the trial. And I submit the best way to do it is every single time that there's something that is slightly prejudicial, that you could say, hey, we wouldn't be in this boat, Judge, if you just granted the severance. You make a mistrial motion. Your Honor, I got to move for mistrial because of that shit that just happened, okay? And I'm renewing my motion for severance. We can stop it right now, just sever the case, and we'll try them separately. Make that motion every time, because that's the only, at least in California, if I don't make it again at trial and during trial, I haven't preserved it. I've waived it for appeal. And I think you've beaten the judge down. Look, Judge, look what's happening here. The next time the prosecutor wants to come close to that line, what's the judge going to do? Oh, no, we're not doing that. I'm not hearing Sheela up here bitching about a severance again. So you just got to keep doing it. Let's see what else did I put on here. Okay. Separate trials, it's easier because you can dump on the co-defendant. You can paint them as the more sophisticated. You can bring out what they have. And when you're doing it separately, you don't feel as bad when you're dumping on the co-defendant, when it's in a separate trial. When you're together, it's hard. It hurts to do it because we want to win. I want the government to lose all the time, as much as they can, and I don't want to be helping them. But you know, I need to defend Larry. So we got to do it. And had Gary testified in that case, I would have impeached Gary with his prior felony conviction, perhaps, just to make sure. So if you're doing the smarter, more sophisticated, con-wise co-defendant defense, he's not going to look that way when he comes in waist chains. In those cases, I think you're better not bringing him in. I think you're better bringing a photo in so that you can paint him as con-wise and sophisticated. You know, someone coming in like this doesn't look sophisticated. So if that's where you're going, the more con-wise one, you got to go that way. Let's see what I have here. Your defense is, my client didn't know what was going on, so you got to dump on the co-defendant. And other crimes in the past, you bring in the similar act evidence. The back, where that can backfire, is the prosecution's closing argument in that case is, he's not my friend, he's his friend. Providing they can put a relationship between your client and the co-defendant. If they can't put your client and the co-defendant in some sort of relationship, friendship, acquaintanceship, they don't really have a co-defendant case. You know, I mean, you can't get two guys doing the same crime unless they know each other. So we got the instigator. What else do I have here? All right, so you have this case. And he's your client. What do we do with that? I mean, he barely kills anybody.
He killed the Wade Justice.
Yeah, but you know, he's not grinding them up.
Yeah. And he didn't kill the cop or anything.
Yeah.
And he's going, whoa.
Right. He's just whoa and sucked into it. And that's what you need to do. Sometimes your co-defendant is the one who provides the getaway car. Or the guns. And all of that goes on them. You put it all on them because in that way the jurors are going to go, Larry's not that bad. Hector's not that bad. And it's a little jury nullification. It's a little something. It's given them a reason to throw you a break. So you do all of that, but you can't do it. You can't do it if you don't have a co-defendant. So there are some benefits to having a co-defendant, whether they're with you or whether they're not with you. And you just have to figure out what you can do. But if you have dipshit for co-counsel, okay, it's a tougher road. But on the other hand, you can shut them up. I don't know whether there's times that I've said to co-counsel, look, I'll do the cross of this one. Don't fuck it up. Just keep your mouth shut. You have to say it nicer than that. You have to start with it nicer than that. But a friend of mine, co-defendant's lawyer's up there screwing things up, and Bill gets up and goes over to the podium and touches on his if you ask one more motherfucking question, I'm going to kill you. and Bill's big and said it with meaning, and the lawyer said, well, I have no other questions. And it stopped it. So you can work with co-counsel and sometimes if you have to. Yeah, and if you got dipshit, you've got to shut them up. All right, slide's worthless. The one after this is worthless. Because I had film clips. I had some nice My Cousin Vinny clips, but I accidentally erased them from my computer. So so this would have been a lot longer talk because I had the co-defendant's opening statement, which I love.
Yeah.
Or his cross-examination. Oh, he's a tough one. Remember that? He's a tough one. So those are things that I've learned working co-defendant cases. No law other than Bruton can be your friend. No law here other than figure out what the government doesn't want, which is a severance. I mean, they rarely want to try them separately because they know there's problems. Push them for severance. If you get it, free dumping. You can do whatever you want. If you can't get it, you'll sometimes limit what evidence they can present because of Bruton. Well, I should have talked about one other severance thing. Okay. You can limit what they can do if they've got us together. Another ground for severance in well, we've got antagonistic defenses. We lose on that, don't we? You made a motion for severance on the basis of antagonistic defenses, where the law is, if the only way that I can acquit Tommy is to convict Jimmy by virtue of the different defenses, and it's not just finger pointing. Finger pointing is not good enough. Where the defenses are totally antagonistic. I wasn't there. His defenses, we were both there, but we were insane at the time. It was something like that where they're completely inconsistent. There's a little law that helps us, but most of the time the judges, severance is within a judge's discretion in every jurisdiction. Reviewable on appeal for abuse of discretion. So, antagonistic defenses is one. There's another one where the co-defendant will testify for your client. And at least in California, what I have to do to get that is I have to have a declaration signed by the co-defendant. I will testify for Tommy. I will not testify if we are tried together. If we are tried separately, I will testify for Tommy and I will exonerate Tommy. What some judges will do is they'll force then the co-defendant's trial to go first. Actually, second, excuse me. Because when the co-defendant testifies for Tommy and incriminates himself, then they figure that the government won't have to try the case the second time. So they usually force Tommy to trial us first to try to neutralize the co-defendant. But you can make the motion on that basis that, look, by having us joined together, you're depriving me of a witness. A willing witness, a witness who will exonerate me, and who won't testify if we're joined. And that's a decent one. I filed, I'm litigating a severance motion now, which I'm going to lose because the law is against me. But it just is unfair that I get a certain amount of peremptory challenges if I'm by myself. But if we're joined, we get, in California, it's a life case, so I get 20 challenges. With a co-defendant, the two of us get 20. And then we each get 5 of our own. And to me, that's just not fair. You've cut me down from 20 to 5. Unfortunately, the California Supreme Court has shut that down every time, but I'm still working it. There may be a way. There may be a way to get it. The last time I made that argument, I said, "Look, Judge, why don't we do this? Why don't you just give each defendant 15? I'm willing to go down from 20 to 15, but you give us each 15 of our own, and you give the prosecutor the same, the 30." And the judge went with me on that. And that way I got 15 by myself, but we were working together. It just was a way to try to get the judge to grant a severance. Because, look, Judge, this problem, we'll agree to 15 each. Then we didn't use them. Neither of us even used 10. But we at least had it there. The judge is having to call more jurors, and it's becoming more burdensome. And gosh, can't I make this case settle? And she tried. She didn't try hard enough. I think because she wanted to do a dual jury trial. So she could get her name in the paper because she was running for judge again this year. And that's how that one fell apart. But you do what you can do. So that's basically what I wanted to talk about, was trying to figure out ways to make it. So when you get a co-defendant case, think about, how can I use this? How can I get more investigation? How can I get more experts? How can I get a co-counsel that works versus a co-counsel that doesn't work? And that's all investigation and preparation. And then as you go through it, at preliminary hearings, at every hearing you can, both of you cross-examine, both of you figure out what we need to get out of this witness. You know, there's times we get up, you'll do a good job with a witness. You'll do a masterful job after the next 2 weeks, or these 2 weeks. But your co-counsel may see a little twist, and they can go in and fill that in, just because they're smart, you hope. And they can fill that in, and so you'll get all of the stuff you need at your earlier hearings. Suppression hearings. Sometimes you don't have a suppression motion, but your co-defendant does. That they're going to lose, okay? They're going to lose it, but it's an opportunity to get the officer on the stand, to prepare for trial. So you need your co-defendant to run it, run the motion. You need to work with co-counsel so that the stuff you need asked of that cop just gets kind of slimed in on the edges. So we get that record. But that way you can get, in essence, a chance to cross-examine a witness that you couldn't call because you have no standing. So there's stuff there that they can do, that you can do together. And then try to get it severed so you can dump all over them. Yo, yes.
Where you've been in agreements that have fallen apart, can you share any experiences with that, how it played out? Or where you've heard of it, or?
Oh, heard of it? Shit. I mean, somebody's client flipped. Clients were all out of custody. Clients and lawyers are attending joint defense meetings together, strategy meetings. And at the time that this was happening, co-defendant was meeting with the government on the next day, or had met with the government the day before. But they couldn't not show up for the meeting, because if they don't show up for the meeting, what are they saying? I'm a rat. So they were in a box. They went to one meeting and then they didn't come to any more. But they'd already been talking with the government. So immediately once that happens, you got a whole bunch of motions. Oh, the government's invading the defense camp. They got this guy that they cut a deal with, that they're meeting with, that's sitting in on defense meetings. We need some hearings, Judge. They had the hearings. You know, we didn't get a dismissal. I was in the case, but the people in it didn't get a dismissal. But they could make the government's life a little tougher. You know, as John says in his motion thing this afternoon, make them work. You know, they can create their own problems. In the homicide case that I'm going to start trying now in October, last month, actually April 19th, the DA sent a DA investigator to the jail to search my client and the co-defendant's cell. Not just to search it, they picked up everything in the cell. They took my client's food. Took everything down to the DA's office in plastic bags, then called us up and said, if there's stuff here that you say is privileged, come on down, separate it out. So, so we did all that. But when we then are litigating the propriety of the search, and we got the no expectation of privacy cases when you're in the jail, but that's between you and the jailer. It's not between you and some DA investigator. So the DA's, and they didn't really get bupkis in there, particularly when everything that we claimed was privileged and the judge reviewed in camera. She says, you're right, they get none of that, which would have been all of my client's writings on the discovery about what he thought about this witness and that, which were all his thoughts. So the government got to look at none of that, but they bought themselves a shit pot full of trouble by doing that. And in the co-defendant case where they got somebody sitting in on the meetings, they bought themselves a shit pot full of trouble.
What do you think they hope to find? Some incriminating letter that wasn't between counsel, or?
They were looking to find more evidence of gang membership. They already have a gang. deputy that's gonna come in and say, these guys are in a gang, and this is the gang, and it's a criminal street gang, and all the stuff that they need to prove up in California to get their enhancement. And it's supposedly a gang killing in retribution for something that had happened 10 days before. So they were looking for more gang stuff because they're thin on it. My co-defendant was 15 years old when the shooting happened. Mikey was 18, just barely 18. So the gang stuff they have about our guys being ganged up, most of that happens after the murder. It's a 2007 murder. It doesn't get filed until 2011. So they need to make them more gangy, and they can make them more gangy now. They needed to make them more gangy back in 2007, and they're kind of stuck with what they have there. But yeah, they were fishing for something. So they got all my clients' letters from his wife, from his friends, pictures of his children. They got his little book where he ordered to learn how to draw, so he can draw better pictures to send to his daughter and to decorate his outgoing mail. So now they know how he learned to draw, because I didn't claim that was privileged. And then as a result of all of this, then I start complaining, and the DA said, okay, we're not going to use anything. We're not going to use anything that we got. As the co-defendant, I think they want to use something that was in the cell, some gang stuff. Instead, my client, because I went ballistic about it, they said, we don't want to use anything. So I said, well, Judge, we have to have some taint hearings now. She said, what? I said, well, they looked at stuff. We need to know if as a result of looking at stuff, they did anything. So I think we need to have some hearings. It's a lovely thing. I wasn't having nearly as much fun with this case as I'm having now. And then I got good defenses at trial, so everything's much better there. Any other questions about co-defendants? No? Yes?
Can you just give your bird's eye view of Bruton, the law, versus what you can actually argue?
Bruton's gotten cut back. Marsh versus Richardson, I think, cut it back some. What you're generally talking about is it has to directly implicate the other person. They've tried to sanitize in some cases by obliterating the name or deleting the name. The problem with that is generally the context of what's being said is pointing at the co-defendant, and so that's what's denying the right of confrontation. So they cut back on it some, but the sanitizing by just taking the name out, the Supreme Court said no on that. The sanitizing, then they have to sanitize out the context so that there isn't any kind of reference. You know, if the statement is, Tommy and I walked into the place and shot it up, okay? The Tommy's out, right? Because that denies Tommy's lawyer the right of confrontation. But if it's the two of us walked in, I walked in with another guy, so now we're going to sanitize it. I walked in with another guy. Well, if the witnesses are saying that two guys walked in, the fact of another guy, and there's two at the table, the context is almost implicating Tommy. So he said, well, we can't say he walked in with another guy, Judge. He can say, I walked in and I shot up the place. That's sufficiently sanitized for Tommy's purposes. And then the government's going, well, you know, everybody says he shot up the place. That statement doesn't help me that much. And so you fight over names, you fight over phrases, you fight over implications.
The net effect.
The net effect, because what you want to do is you want to water it down so much that it's just insipid, that it's worthless. So that would be Bruton. Bruton, how old is Bruton? 40 years? Yeah, 40-year-old kid. But they have had some cases since then from the Supreme Court. In California, our Supreme Court was good. It's not anymore. So we're losing more of those cases. I thought Scalia was going to help us a lot on confrontation, and he's doing his best. He couldn't hold out this week. Thomas moved to the other side. That's how the number went. 5-4. So Bruton is the best thing because it's constitutional, and judges are afraid when you say, Your Honor, we've got a constitutional problem here, because most of them don't know the Constitution very and they're afraid anyway. Okay, take your break, because we got Kathy. Thank you. All right, there it was. Dan.
Basically run out of power, so they and NODA just bumped it to.
Really?
Might be trying to come get in. Oh, that.
What's he look like? Is the name actually?
Yeah. Okay, well, recently he's been wearing beard, but the constant expression on his face is this.
Kick back, kick back.